You filed your I-130 14 months ago. Your wife is a U.S. citizen. You've been together 6 years, married for 2, and last Tuesday, a letter showed up from USCIS that wasn't the approval you were expecting. It was a request for evidence, 12 pages long, asking for joint tax returns going back to a year you weren't even living together yet, a notarized letter from your landlord, and proof that a trip you took to visit your mother wasn't secretly a second life. You have 30 days to respond. Your attorney, if you have one, is telling you not to panic. And somewhere on YouTube last night at 1 a.m., you typed in a search that led you here. Will filing a marriage-based green card get you deported? That question used to have an easy answer. In 2026, it doesn't anymore. And by the end of this, you'll know exactly why and exactly what to do about the letter sitting on your kitchen table right now. Here's the actual shift, stripped of legal language. On May 21st, 2026, USCIS issued something called Policy Memorandum PM 602-0199. The title alone tells you the mindset behind it. Adjustment of status is a matter of discretion and administrative grace, and an extraordinary relief that permits applicants to dispense with the ordinary consular visa process. Translate that out of government speak, and it means this. USCIS now treats getting your green card without leaving the country, which is what adjustment of status is, as a favor they're extending to you, not a right you've earned by meeting the requirements. Before this memo, if you met the legal criteria, genuine marriage, no disqualifying issues, clean paperwork, approval was close to automatic. Now, an officer can look at your entire file, decide you technically qualify, and still deny you, because the standard has shifted from did you meet the bar to did you meet the bar, and does this officer, using discretion, believe you deserve extraordinary relief? That distinction sounds small. It is not small. It is the difference between a checklist and a judgment call. So does that mean filing gets you deported? Not directly and not automatically. But here's the part almost nobody explains clearly, and it's the part that matters most. If your adjustment of status gets denied and you are what's called removable, meaning your legal status to be in the country independent of the pending application has already lapsed, USCIS can issue or refer your case for a notice to appear. That's the document that starts removal proceedings. It's not a punishment for filing. It's a consequence that was always technically possible, but under the old framework, it rarely got triggered because denials were rare and usually procedural. Now, with discretion driving more denials, more of those denials are landing on people who are also, separately, out of status. And that combination is what's pulling filing and deportation into the same sentence for the first time in years. Picture 3 people watching this video right now, because odds are you're one of them. First, the spouse of a U.S. citizen, filing from inside the country, entered on a visa that expired 18 months ago. That's your composite case with the RFE. For this person, the marriage being real isn't the whole battle anymore. The file needs to actively build a case for favorable discretion, meaning documented ties, community involvement, tax history, the kind of paper trail that used to be optional and now functions as a shield. Second, picture an employment-based green card applicant, someone on an H-1B, company sponsoring their I-140, waiting on a priority date, who assumes none of this touches them because they're not in the marriage-based lane at all. It touches them too. USCIS has signaled category-specific guidance is coming for employment-based and parolee adjustments next, and the discretionary posture of the memo isn't limited to spouses. It's a philosophy shift across the whole adjustment of status system. And anyone with a gap in their status history, a past denial, or an employment authorization lapse is now more exposed than they were a year ago. Third, Picture a student on an F1 who just got married to a U.S. citizen and wants to adjust status without ever leaving. This is where people make the costliest mistake on the list, and it has nothing to do with the marriage itself. It's leaving the country before advance parole is approved. Under the regulations, if you depart the U.S. while your I-485 is pending and you haven't secured advance parole first, your adjustment application is generally considered abandoned the moment you cross that border, no matter how strong your marriage case was. People still do this every month, usually for a funeral or a sick parent, not realizing the timing turns their entire case to zero. Why is USCIS doing this? Not because marriage fraud suddenly spiked. The stated justification is administrative. The memo frames consular processing abroad as the ordinary path Congress intended, and adjustment inside the U.S. as the exception. So tightening domestic adjustment is being presented as a return to that original design, rather than a new restriction. Whether that legal theory holds up is genuinely contested. This is an interpretive memo, not a law passed by Congress, and it wasn't run through the normal public notice and comment process regulations usually require. That matters because interpretive memos are more vulnerable to court challenges, and there is real litigation forming right now from applicants who made major life decisions, quitting jobs, signing leases, having children, based on the old, more predictable standard, only to find the rules rewritten under them mid-case. Which brings us to the mistake you're most likely making without realizing it, and it's not about your marriage at all. It's about your paperwork sequencing. People are still filing I-485 packets the way they did in 2023. Marriage certificate, joint lease, a few photos, done. That worked when adjustment was close to a formality. It does not work now. Every adjustment applicant also needs Form I-693, the medical exam completed by a USCIS designated civil surgeon, submitted at the time of filing. This has been required since December 2024, and incomplete or missing medicals are one of the fastest ways to trigger an RFE that eats months off your timeline. On top of that, if you're filing I-130 and I-485 together, concurrent filing, expect the I-485 decision to take roughly 8 to 9 months on average right now, though that swings hard depending on your local field office. And interviews, which had briefly been waived for straightforward cases, are back to mandatory for essentially everyone. If speed genuinely matters for your situation, USCIS did expand premium processing to cover certain family-based petitions in 2026 for a fee around $2,800, but that only guarantees action on the I-130 petition itself within 15 calendar days, not the adjustment of status decision, so it moves one piece of the puzzle, not the whole board. Here's something almost nobody tells you, and it's a genuine reversal from what you'd expect. The discretion memo is not a death sentence for well-documented cases. Go back to Matter of Array, the decades-old precedent this entire discretionary framework leans on. It holds that favorable discretion generally follows when there are no adverse factors, and where negative factors exist, they can be offset by positive equities like family ties. That framework hasn't changed. What's changed is that USCIS is now applying it more aggressively and to a wider set of cases. A genuine marriage, backed by real financial entanglement, consistent addresses, and a clean immigration history, remains a strong case under this memo. It just now needs to prove itself instead of being assumed. So back to that RFE on the kitchen table, and the question that's been sitting unresolved this whole time. Will filing get you deported? The honest answer is that filing itself never deports anyone. What creates risk is the combination of a discretionary denial and an independent, pre-existing removability problem, meaning your status was already precarious before you ever touched Form I-485. If you entered legally and maintained status up to the point of filing, a denial under this memo is a serious setback, but it does not automatically flip into a notice to appear. If you're out of status already, the equation changes, and that RFE stops being routine paperwork and starts being the most important document you'll respond to this year. If you're in this spot, here's what I'd tell you, plainly. Don't treat your RFE deadline as a formality. 30 days moves fast, and a rushed, thin response is worse than a complete one filed a week later, if that extra week gets you real documentation. Build your file like you're building a case, not filling out a form. Joint finances, consistent history, community ties. Everything a RAI says counts in your favor. And before you make any decision involving international travel, confirm your advance parole status first. Every single time, no exceptions, because that one mistake has ended more strong cases than any RFE ever will. This memo changed the temperature of the whole system, but it didn't change what makes a marriage case succeed. It just raised the bar for proving it. If this helped make sense of what's actually happening right now, subscribe, because next I'm breaking down exactly what USCIS officers are looking for in a discretionary approval under the new standard, line by line, the part almost nobody's explaining correctly.